Buenas Jesus, y minute 35 na legislatura in Guam is back from recess. Good morning, colleagues. Yesterday or last night, when we left, we were on bill number 312-35LS as substituted. Senator Therese Terlahi was on the main motion, and she has amendments. And from my understanding, I see that there's more than several amendments on the floor, and we'll get started at this time. I will allow you to work the amendments now. So you have the floor, Senator Therese Terlahi. Good morning.
Good morning, Speaker, and good morning, colleagues. So we're on Bill 312, which was revisions to the Civil Service Commission enabling statutes, and particularly dealing with their authority to do audits on positions and determine whether they have been filled legally, whether the person is qualified to fill the position. And this is very different. And this is an authority pursuant to Section 4403D of the Enabling Act of the Civil Service. In 4403B, it also allows the civil service to be the adjudicator for adverse action appeals. So it's very clear from the enabling statute, these are two separate authorities of the commission. One is to, of course, hear adverse action appeals where the manager takes an action against an employee, and the employee gets to appeal that to the civil service, versus this action that we're considering today, where the civil service goes in and investigates a position, how it was hired or how they were promoted, whether that was in conformance with the merit system. So this is very critical to our merit system. And so as I said yesterday, I'd like to begin with the, okay, so there are several amendments. And they're labeled differently, and I'm going to begin with the one that is labeled B312 FAT. It's B312 FA TMT L4, page 5. FA TMT L4, page 5. This is an amendment to delete on page 5 of the bill, section 4403, subsection 6. I guess I'll proceed. Okay, so subsection 6 of the bill, as written, is this. This is a new provision that will guide the civil service, and it gives them 6 months to do these post-audit investigations of the hiring or promotions. And as I said yesterday, the testimony says it was pretty much an arbitrary number, put in the bill, and that if we wanted to protect the merit system over every other concern, that we would put no statute of limits. In other words, if the government or the civil service or no one makes a complaint within 6 months, according to this language, they could stay in that job forever despite not being qualified. So what I'm proposing to do is to strike that language and leave no statute of limits. In other words, if someone discovers that you are not qualified to be the medical examiner, then we should have, as a government, be able to protect the merit system and say that hiring was null and void because it didn't meet the requirements. Same thing with promotions. So this is just, again, to protect the fairness for all of the others who are qualified and fairness for those who may have applied and didn't get selected, fairness for all other employees that have to follow all the rules and be hired, based on their qualifications or promoted based on qualifications. And so this just keeps the government's authority to declare null and void any hiring that is contrary to the merit system.
Thank you, Senator Therese. On the amendment, are there anyone wishing to speak on the amendment? Senator Paris, I will recognize you on the amendment.
Thank you, Madam Speaker. I rise in support of this amendment. I think it's important that we ensure accountability in our system, especially when it comes to the merit system. And I'm a supporter of this. I think it's important that we hire and maintain qualified employees in the government. And I believe this is one way to ensure that accountability is always there. It's a measure, it's an accountability measure that can be utilized without any statutes of limitations. Stu's Masi.
Thank you, Senator Paris. Anyone else on the amendment? Senator Mary Torres, I will recognize you.
Thank you, Madam Speaker. Madam Speaker, first of all, I object to this amendment, and let me explain why it is so critical to have this timeline in place. The Civil Service Commission sent us some feedback after the public hearing when it was asked how many cases get filed and how long does it take for people to file cases. And without a statute of limitation, which is what it currently exists, there's no statute of limitation. And what came back to the committee was that in the post-audit reviews and in the complaints that are filed by people who make complaints that somebody was hired who is not qualified for that position, from 2018 to 2020, there were only 17 cases filed. But what is not right about the way things are filed is without a statute of limitations, complaints are filed anywhere from 3 days after a person is hired to 23 years after a person is hired. So that is why the Commission believed that it was necessary to put a statute of limitation in place. Now, the idea that somebody is going to get away with being unqualified, that is why we are tightening up this part of the statute, so that those sorts of things that were preventing people from being reviewed and action taken against them, this bill corrects that. But it was vital to have a statute of limitations so that people understand the parameters to make it fair, not only for the employer, but for the employee. And I'm not talking about an employee who lies. And we keep focusing on when someone lies. We're not talking about people who commit fraud. We're talking about errors in the processing of an application and in the hiring of an applicant to a position. That's what we're talking about. Does the person's qualifications match the positions and the qualifications for the position? That's all that we're talking about with post-audit reviews. So it is vital to put a statute of limitations so you don't have a situation where a complaint is made anywhere from 3 months to 23 years, which is what's happening right now. And also you contain it to that probationary period where it's wide open and it's so convenient and within the parameters to fire someone if, within the probationary period before they're permanized. So I highly object to this. Having a statute of limitations was so important to the Commission. Otherwise, it's like lawless land. People can do whatever, sometimes just for vendettas, political vendettas. So please keep the 6 months of statute of limitations in. People have to understand if they're going to take action and make a complaint, it has to be timely. That is a very standard procedure in our system. Timeliness, time frames. If you're going to do something, do it within a time frame. So I object to this amendment. I think it guts what was one of the most fundamental reforms in this part of the statute that the civil service asked for.
Thank you, Senator Torres. Minority Leader, you are recognized.
Sujus Masi, Madam Speaker, for the opportunity, and good morning to my colleagues as well. I'd like to thank the author for this amendment. It raises the concerns I had yesterday when I spoke on this bill. You know, the devil's in the details. If you look at this paragraph that's being stricken out, you'll see that there is a statute of limitations on those individuals who filled out applications that didn't put the correct amount in there, the correct information in there regarding their credentials or their experience, let alone even maybe certificates or degrees. You know, 6 months, most probations, I think, are a year long, and here we're allowing a 6 months time period. So you know, Madam Speaker, you have to ask yourself, what are other jurisdictions doing as well? If I'm not mistaken, I was told that most jurisdictions of the other states do not have a statute of limitations. And there's a reason for that. You don't award people, you know, for being able to keep their head down low and, you know, being able to get through without being caught. This is an excellent change to this legislation. And I stand in full support and ask my colleagues to really think about this. Do you really want to award somebody who's not justified to be in that position? Or do you want to uphold the thousands of Government of Guam employees who got their positions justly and with credit and within the merit system, which the Organic Act of Guam required this body, as well the executive administration, to uphold the merit system. That's what we're protecting here. Thank you, Madam Speaker.
Thank you, Minority Leader. Anyone else on the amendment? If not, Senator Therese, you can close.
Thank you. Again, I think it's incorrect to say that the commission was all in favor of this as the statutory period, because the testimony shows that they were all over the place. Some wanted 3 years, some wanted 2 years, some wanted 1 year. Some said and Eric Miller, who's the Attorney General, said, you're right, it's a balancing issue. You bet they're trying to protect the merit selection system. If that were your only concern, that the only thing is of value to you was to protect the merit selection system, there would be no statute of limitations. And I do think that is what we're trying to do with this bill. We want to make it better. We don't want to weaken our merit system. And this is really the only protection employees have when they see promotions that are not fair. And I'm not saying fraud. I'm not the one saying that. I'm saying error, where the government hired in error, or they filled a position. And we could say in bad faith by the employer, the government, the managers, but not the employees. I'm not saying anything bad about the employees. I'm saying all the other employees. If you hire me as your, doctor, I hope that you can complain about that. I'm not qualified, so I shouldn't be in that position. And it's really just that. No other motive. It's just if the position says you should have these qualifications to be promoted, then you should have those qualifications to be promoted. And when we start watering that down or weakening that by, allowing somebody to hide for a period of time, I just think we're not doing our part to keep up the merit system as stated. And I think if you just think about the reality, I, as a senator, hear many complaints about things that happen in agencies, and sometimes I look at them and they're a little bit, they're not just like last month, they're like more than 6 months ago, right? And for me to figure that all out, follow up on it, it's gonna take some time. And I just think for employees to know who's getting hired or who's not getting hired in another agency with qualifications or not, it's not that easy. And so I don't see why we would preclude complaints after the 6 months. And 6 months, again, it's pretty much arbitrary. And so that's the reason for this amendment. And so I urge my colleagues, please, let's just keep this power with the commission, that they can investigate it and they can make this determination anytime. That's their power. Thank you.
Thank you, Senator Therese. There has been an objection to this amendment. All those in favor, please signify by raising your hand.
Madam Speaker, roll call, please.
Please signify by raising your hand. Please signify by raising your hand.
Can you clarify? So it's in favor of the objection or in favor of the amendment?
No, the amendment was proffered by Senator Terlahi. There is an objection. If you support the amendment by Senator Therese, please raise your hand.
Roll call, Madam Speaker. Roll call.
Please signify by raising your hand, please.
I'm sorry. I was, Madam Speaker.
Madam, I will take a minute. I will take a moment's recess. Imina 35 na legislature in Guam is back from recess. There has been an objection to this amendment. I am humbly asking, please, if you support Senator Therese's amendment, please signify by raising your hand. Motion fails. Senator Therese, you still have the floor. Thank you.
All right, my second amendment is labeled B312,
Give me.
FA, TMT, L4, P7. Line 4, page 7. I'm bifurcating this. So the amendment is to delete Section 5 of the bill. Section 5 of the bill currently says that the rules and regulations by the Civil Service Commission as to how they are going to treat these post-audit investigations, it needs rules and regs, and those are supposed to be adopted pursuant to the AAA. This section of the bill, which I'm trying to delete, exempts the Civil Service rules and regs from going through the AAA process and makes them skip the Attorney General's office and come directly to the legislature. And I described yesterday the different possibilities for any senator who wants to take these rules and skip the Attorney General. They always have that prerogative. But I think if the Attorney Generals are holding up the rules and regulations for some reason, then we haven't learned the reason. And I don't want to bypass that process, and then we get stuck here trying to figure out how to make them better without input of the Attorney General. So this is just to strike this exemption to the rules and regs AAA process and to require the Civil Service to continue to pursue the Attorney General's input on their rules and regs. And I think that's fair. That's how all of the other rules and regs are implemented. So it would be just to delete Section 5 right now.
Thank you, Senator Therese. On the amendment, Senator Regine Viscoli, you are recognized.
Sudos Masi, Madam Speaker, and good morning, colleagues. I just wanted some clarification. This is to amend Section 5 of the bill, and this is line 4, page 7. That's the correct amendment. Am I right?
That's correct.
Okay, thank you.
Thank you, Senator Lee. Anyone else on the amendment? Anyone else? Senator Marsh Taitano, you are recognized.
Sudos Masi, Maska Helu. I do support this. It had caused me great concern, and I do appreciate the author of the bill for working to fix an issue, but this is an area that did cause me concern. It seems to me that the issues that are brought before CSC, they're technical, they need to be as just vetted and validated as much as possible. We're dealing with people's jobs, their reputations, just highly sensitive and highly important issues. And so I know that I would not feel comfortable taking a look at rules and regulations without the AG's opinion. So I just wanted to share that concern. I think especially for an entity such as this and for the significance of what's involved, that it's really important to get that opinion from the office that has that ability, which quite frankly, my office would not be able to have the level of ability nowhere close to what the AG's office would be able to provide.
Thank you, Senator Taichano. On the amendment as proffered by Senator Therese Terlahi, are there anyone else wishing to speak? So Senator Joseph Augustine, I will recognize you.
Thank you, Madam Speaker. I'm just curious, looking at the amendment, and I'm trying to look back at the bill itself, it's to ask that the legislature gets to take a look at it, and we're saying, let's strike it. Legislature don't need to look at it, let it go to the AAA audit, right? Let it go to the AGs. When it comes to this body, the bill states that this body will determine, approve, or disapprove. This body can immediately say, I'm asking for the AG's opinion on it. This body can also say at that hearing, you will conduct a AAA, I'll see you in 9 days. Because the key to to this bill, it just says that we got to hear it in 75 days. I'm trying to find that again. Am I correct, Madam Speaker? I'm just trying to clarify what it's saying. Now we're saying, no, we don't want to hear it. We want the AAA to go through it. We don't want to hear it at all. Really, that's what we're saying by taking it out. Not unless somebody can please clarify exactly what you're trying to get at, because my understanding on the bill is that you've got to hear it. The legislature must hear it. We've done this with many other issues, bond issues and other stuff. So let's not kid ourselves by saying, no, we don't want to hear it. We don't want to hear it within 75 days. We don't want to hold our body speaker to have a hearing and refer it to its committee. We don't want this body to have a committee of the whole to be accountable for what is being presented.
Thank you, Senator San Augustine. I will ask Senator Therese, would you like to yield?
Sure, if that's a request, yes. That's incorrect. The bill, Section 5, exempts the civil service rules and regulations from the AAA process. And the AAA process absolutely includes the legislature. After it gets the AG's approval, it has a public hearing by the entity, the agency, and it gets the approval of the governor because it's an executive branch request for rules and regs. Then they come here. And then, yes, we still have that opportunity to do all the things that my colleague has expressed. But we would be able to do it with the review of the AG. And really that's all that this section of the bill is trying to bypass. It's the input of the AG. And I just feel like these are the most highly contested proceedings on Guam, civil service proceedings. We've seen them take years. And I just, for those rules and regs, I mean, it's just, it's really just very simple. It's let's not skip that one step where it goes to the AG and the governor, and let's just require that, as all other rules are required to conform with the AAA. And yes, it will come here, and yes, we will have an opportunity to have another hearing and to do our due diligence with those rules and regulations, but we would be doing that with the benefit of the Attorney General's review, which I have found to be very beneficial. Thank you.
Thank you. Senator San Augustine, does that help?
Madam Speaker, and my colleagues, we're all looking at the same bill. We're all looking at page, let me see, what's this, page 7? We're looking at striking line 4, I guess all the way down to line 21. Am I correct?
Yes.
Okay. And I don't know, I'm just curious. I was a GovCom employee, classified. And if anybody here can tell me how many of you have went before the Civil Service Commission, I'm gonna bet money that probably nobody else but myself. So and I went through that to fight for my job back. And I won. I went to court, I won. I got my job back. So when I look at this, and the civil service is going to put the rules and regulations together, send it to us, and it says, the committee of the whole, okay, as you're going down on line 8, I don't even need to read all this, but my colleagues, please just read what they're asking to strike. And it says after the public hearing, 90 days, everybody can say no, it doesn't mean that. I know what it reads. I graduated. Thank you, Madam Speaker.
Thank you, Senator Joseph Augustine. Senator Lee, did you have your hand up? You may proceed.
Sujus Masi, Madam Speaker. Madam Speaker, I have a question, and maybe this is an opportunity for clarification, either from our member who has introduced this amendment or from the author of the bill, but there was made mention in a previous comment that this draft of these rules have been with the Attorney General for a few months. And so I just wanted some clarification on how long the Attorney General might have had this. Is it a few months, or if either the mover of the proffer of this amendment or the author of the bill could yield to that question?
Thank you, Senator Lee. Senator Terlahi, would you like to yield? Or do you want me to yield? Do you have an answer to that?
I heard the same thing.
Senator Torres, do you have an update to that,
Yes.
ma'am?
Actually, Madam Speaker, what was presented to me by the Civil Service Commission is that per statute 4 GCA section 4403D3, they're required, the commission is required to they're required to promulgate rules and regulations. And so in 2008, 2009, they came up with rules and regulations and submitted it to the Attorney General's office. Those rules and regulations were never acted upon by the Attorney General's office. But also in the course of time, because of court, certain circumstances that happened with the court, those rules and regulations are obsolete, more or less. And so the Civil Service Commission will have to restart the process of submitting rules. Now, so what I understand is that the AG's rules sat with them, the rules sat with the AG's in draft form for close to a decade. Now, the reason that Section 5 was put in the way it is it was felt that this was a way to expedite the promulgation of rules and regs for the Civil Service Commission. They give it to us. We conduct a public hearing. We allow the 90 days to elapse before we take action. It has to be put into a bill form. So the whole process of review by the AG, public hearings, the ability for the AG to testify and weigh in on it, all those things are in place. The timelines that are consistent with the AAA are all in place with this. But I just want to reiterate that the reason it was put in here was it was believed by civil service that it was a way to expedite the process if we could take it on this way. And it really is just to comply with the statute that says you have to promulgate. So, but in terms of bypassing, I believe that there's ample opportunity for the AG to weigh in on it. And it starts with the civil service drafting and submitting it, and everybody weighs in. And the governor ultimately will have the up or down when she signs that bill that will promulgate the rules and regs or put them into the GAR. I hope that's clear. So that's it. It was just, 10 years many felt was so long. And if this could work better and we could facilitate, that was what I agreed to do when they asked, was this a way we can do it? I said, we can try to do it this way. And it's lawful and it's reasonable.
Thank you, Senator Torres. Senator Regine Lee, does that help?
Thank you, Madam Speaker. Yeah, it certainly helps to clarify. I think there was some previous speaker had made mention of, this has been with the AG for a few months, and I'm grateful for the clarification that it's been closer to a decade, 10 years, Madam Speaker. So, and one of the other concerns that I had, was something that was brought up, I think, by the proffer of this amendment, that the Attorney General won't have the opportunity to weigh in. So I'm really grateful for that clarification that the AG would still be able to weigh in at a public hearing, and everybody in our community would be able to weigh in. And I guess my concern is that at this point, the Civil Service Commission is going to have to start from square one. And so that's 10 years that we've been waiting. So we'd have to restart the process, especially given some of the more recent cases. And so I'm very concerned that if the Attorney General does not act on these, which they have demonstrated that they have not done in years, then this amendment would simply have him continue to languish and just collect dust. And so with that, Madam Speaker, I object to this amendment.
Thank you. Senator Lee, anyone else? Minority Leader, you are recognized.
Hi, Adi. Madam Speaker, I stand in full support of this amendment because it does strike out Section 5 altogether. And if I'm not mistaken, and maybe we can seek legal advice on this, but you can't have a legislature, especially if this passes January, the requirements, you can't have a legislature dictate another legislature to do something, if I'm not mistaken. So, Madam Speaker, the striking out of Section 5, I think is important, number one. But, and I would like to seek legal guidance to confirm that. But it makes sense, Again, we should not allow, we should allow the process and not allow those who are unjustly or unrightfully put in a position that they weren't supposed to be there in the first place. And we should give the Commission every authority, as well as the Attorney General and everyone else involved, the opportunity to continue to research any information they need to solidify a case. So I stand full support, but I also like, Madam Speaker, to take just a short recess to confirm with legal.
Minority Leader, I will allow you the moment's recess to consult with legal. We are in a moment's recess. Imina 35 na legislature in Guahan is back from recess. Colleagues, when we last left, took a break for legal opinion. Minority Leader, you had the floor. I will recognize you at this time.
So, Judith Mossy, Madam Speaker, I had the opportunity to speak to legal about this. And going back and forth, it's basically binding this legislature to the next legislature is the concern that I have here. In doing so, it was said that we have the opportunity, if whatever that's said in this section of the law, we can easily in the 36 repeal it, and not keep us bounded through anything, whether it's to review the process or not. So after hearing that from legal, it sufficed my curiosity on moving forward with this. Thank you, Madam Speaker.
Thank you, Minority Leader. Anyone else on the amendment? If not, Senator Therese, you may close on the amendment before we take the vote. You are recognized.
Thank you. Again, on my amendment to delete the section that would say, notwithstanding any other provision of law, the rules and regs would come straight to the legislature, would bypass the AAA regular process and go to, public hearing, would go to Attorney General review, would go through the governor, and then be submitted to the legislature for the legislature to do all the things that are listed here. But we're shortcutting it, yes, by saying notwithstanding any other provision of law, meaning notwithstanding the AAA process. And all I'm saying is there are times to shortcut, for example, when we're in an emergency, we want to shortcut the rules perhaps, or the enactment of rules, but to shortcut making the Civil Service Commission rules, I feel like it's maybe the last time we want to do that. And if it's been stuck at the AG's office for 10 years, if anybody thinks that's normal, it's not normal. There's something wrong with the rules. And the AG probably, is trying, or probably somebody at the commission didn't follow up. I don't know, we don't know all the facts, but all I'm saying is we're trying to make a judgment here by taking the AG out of the process and saying, we don't need you. And your hang up with the rules, we're going to bypass it. I'm not saying that that's reasonable. It's unreasonable to hold rules for 10 years. But how many times has the AG changed in 10 years? At least twice. So I'm just saying we don't know the real reason. And we've seen case after case come down on civil service, and perhaps the rules are just completely irrelevant at this point. And after this bill is passed, the rules are irrelevant again, and they have to be redone. And so I'm saying they should go through the AAA process. That's all. Just like every other agency and every other set of rules. That's all. Nothing personal against anybody, nothing, but I'm saying these rules are done for transparency. The AAA process is our #1 transparency tool. It's to make sure the I's are dotted, that the public knows exactly what you're trying to hold them to, that they have an opportunity for input. And we've actually written into that process 2 opportunities for input during that agency process and when it comes here. And so I just don't think we should shortcut that. We're talking about, giving people the ability to legitimize hirings contrary to the merit system. I think it's very, very important that these go through the AAA process, that they get absolute transparency, that we know that the AG has every opportunity to work with the commission to make the rules legal according to the AG. I just don't think, if we're not going to exempt every other agency from the AAA process, this is not the time to exempt this one agency from the AAA process. I actually thought this was the most harmless of all my amendments, because all it does is say, follow the regular rules, please, Civil Service Commission. Let's not shortcut you here. And if any senator really wants to shortcut, then get the rules and bring them in here and make a bill to pass those rules. But let's not give them the authority to bypass the AAA by statute. Thank you, Madam Speaker. So I urge my colleagues to please pass this resolution, this amendment. Thank you.
Thank you, Senator Therese. On the amendment proffered by Senator Therese Terlahi, there has been an objection. All those in favor of the amendment, Therese Terlahi amendment, signify by raising your hand. Seven, right? Where? One? Guys, can you make sure you raise your hand so we make sure we have the count? 1, 2, 3, 4, 5, 6, 7, 8. Motion carries. Senator Therese, you still have the floor.
Thank you very much to my colleagues. Now, the rest of the amendments to the bill are all similar.
I apologize, Madam Speaker, if I could just, point of order on that last
Please
motion.
state your point of order.
On the last motion, if I could just request a brief recess?
On the last motion, yes, we will go ahead and take a moment's recess. Imina 85 na legislature in Guahan is back from recess. Senator Lee, you still have the floor.
Sejus Masi, Madam Speaker, and I thank you for that opportunity for the recess. Again, we were looking at the amendment proposed by Senator Terlahi to amend Section 5 of the bill, and we were talking about striking Section 5, that again was clarified line 4, page 7. But there is language beneath that I don't think was fully discussed or vetted. So if we could have an opportunity to reread that and have an opportunity to clarify. I don't think that was
understand.
read into the record, and so I just want to make sure that we're all on the same page here.
I understand. Duly noted.
Point of order,
give
Madam
me-
Speaker. Yes.
Hold on a second. I will confer with the clerk. This issue came up before, and I just want to get a clarification. A moment's recess. Clerk? Colleagues, y mina 35 na legislatura in Guam is back from recess. It's 11:30 right now. Clerk is going to confer back to the tape. It's 11:30 right now. We will go ahead and take a lunch recess and come back at 2 p.m.